What's up? What's up, bitty do? Welcome to a brand new episode of Philosophy Culture. So yeah, I'm here with my bro, Carsten, as always. What's up, dude?
What's up, dude? Emils, as always.
Yeah,
How are you doing?
I'm good. I'm good. And you?
Awesome. I'm doing well as well. Yeah,
Cool, 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 coolio. And yeah, so this episode we will talk about intellectual properties. What more, Carsten?
exactly. So, as you said, intellectual properties, and we will go through nine categories of intellectual properties that are somehow related to each other. Um,
Yeah,
you will
and
find out more in the episode. So,
for sure, for sure. Check
check
it
it
out.
out.
Alrighty, so intellectual properties.
Yes,
That could be like a song title. Intellectual properties.
somewhat
Whatever.
possible.
So, huh?
Possible. No, I was just saying possibly.
Yeah.
Nothing more. Yeah.
All right, all right, all right.
All right. Okay. Good. So, shall we always start with the generic question,
Generic.
general question?
Nah, man. It's the classic. No, I'm kidding. Nah, but yeah, yeah, yeah. Of course, of course.
Okay,
So this time I'm gonna ask you first.
okay,
Because it feels like you have always asked me the question, then I answer, and then you say your take after me. But what, yeah. So why do you think it is important to talk about intellectual properties? What are your initial thoughts?
I think that I think it's important to talk about those because I think they become more and more important than general, especially as everything becomes so more digitalized.
Mm-hmm.
Uh, and you could basically create your own logo and yeah, all kind of intangible assets that you maybe want to make more private or more controlled, so to say. Um, and so yeah, I just think and it's also good to just talk about it to learn more about it and to sort of get to know more things about the topic.
Yeah, yeah, yeah.
Um,
Of course.
so yeah, that would be my short answer. How about
All
you?
right. Yeah. Well, as we I will reference back to our episode with Tim. He said that he in one of the areas he wanted to make money is through royalties, which is a form of copyright. No, dare I say? I think we will get back to it. Yeah, yeah, uh, in the episode. But so that is where the initial idea came from, and also we see like throughout history that things like patents are really instrumental in like other people's careers and work. Like we have Edwin Land, and also I listened to an episode of Founders Today about the James Dyson. So he's like this inventor of the Dyson vacuum cleaners, and like the patent, he had like some troubles with it as well. Yeah. Like I think his first idea was like stolen by his sister. I'm not sure. We'll probably make an episode about him later on, but yeah, yeah, yeah. So it's important. It's important in careers, and it can also work as a investment, as an investment vehicle as well. Like royalties, like copyright when you can like license work is really interesting. So yeah, I'm interested to talk about this for sure. So another investment tool, so to say. That
Exactly.
was I don't know if that was a good answer, but
Yeah, I
um,
think that was a good one.
I hope so.
Yeah. Yeah, I think so. All right. So the first one. So we are actually following a sort of list, right?
Yeah,
Um,
so we have like this PDF document that I found on Google. So it's like European IP intellectual property help desk, your guide to IP in Europe. So we're gonna be more focused on Europe. So, but I assume the same rights exist all over the world, but maybe they are protected or they work in other ways, I assume. But yeah, hopefully this will not be a obstacle, and you will still gain some interesting insights about intellectual properties.
yeah. I think the laws will probably vary depending if you're in, for example, US or you know Asia, um, and so on. But yeah, I think we'll try to do or like summarize them as good as possible, right?
Yeah, yeah, yeah.
Yeah, maybe not dive too much into the legislative part of it.
Yeah, since we are not really that well read upon this
Yeah,
topic, so
yeah,
should we say the like say all the types now in the beginning? Then we can go like I don't know, or how do you feel like doing it?
we could do that. Yeah, we could do that.
So that's
Yeah,
yes.
yeah. Let's go. Yeah,
All right, so this is page 3. I think we will probably link this PDF somehow in the what you call it, the descriptions, right?
yeah,
But yeah, so on the we are on the page 3, so contents. And first off, we have trademarks. Second off, we have industrial designs. Third off, if that is how you can say it, we have patents. Fourth is utility models. Fifth place is trade secrets. Sixth is copyright. Seven is databases. Eight is domain names. And nine is geographical indications. Voila.
yep.
Hope I didn't go too fast.
Oh no, it was good. It was good.
All right. So, what is a trademark? Do you want to?
Sure. So it would basically be explained as an exclusive right over the use of a sign in relation to the goods and services for which it is registered. That's basically the PDF's sort of explanation of it. Um, yeah, and I would sort of trademark. I would basically put it as something you can connect to a sign that you could relate to a service or a good
Yeah,
very easily put.
for sure.
Um, and it's interesting because here in the document they also have words, personal names, logos, letters, numbers, colors, shape, packaging, and sounds. So it doesn't necessarily have to be like a sign, right?
Yeah,
Uh, so for example, yeah, a good example would be the BMW
yeah.
sign, right?
Logo. Yeah.
Logo. And then we could also have numbers. That's a good one. Numbers. Come up with a number that you could sort of use.
Why do you
Yeah,
think that's a
yeah.
good one?
That's a hard one. Or maybe it's just me that I'm completely off.
What are you
Uh,
thinking? Like, what are you thinking about?
no, like numbers that you could sort of connect to a good or a service.
Well, trademark, like I don't know. I feel like it doesn't necessarily always have to be related to, even though it mostly is related to businesses and services. But for example, when I think of numbers being a trademark, I'm mostly like thinking about athletes.
Yeah, I was also thinking about CR7.
Yeah,
Like
and
number
like
three.
Michael Jordan had 23, and I think Neymar had like I don't know 11 or I'm not sure. Or
Yeah.
and test and Messi with the 10 or I don't know. Uh, but I guess
Yeah, that's true.
their names are also uh, in a way, since they are so famous, also synonymous with a business, since they all probably have their own clothing line. I don't know. I'm not sure if Messi has anything like that, but I'm sure they have something related to their name. So uh, I wonder if that is a official trademark of theirs.
I mean, I think it could be, to be honest, because I think Cristiano Ronaldo has CR7,
Yeah,
which would be his trademark in this case, which would be a combination of letters and numbers, um, obviously.
yeah, yeah.
Um, and I think it would also be a logo. I think it depends on how you look at it
Well,
and how you interpret the laws.
yeah, for sure, and I think that can work as a logo as well,
Yeah,
because names can be logos. Um, so uh,
yeah.
when we were gonna come up with our logo, we me and Costin went through these different types of logos, right?
Yeah.
I can't really recall the exact types of logos, but uh, well, there was like character logos.
Oh yeah,
Yeah,
exactly.
well, like yeah. So that kind of goes together with that. But yeah, I don't know. I feel like this is essential to know when you are thinking about branding. So it's like all from colors to sounds. Like we have when we listen to Gary V, he has like this. I don't know. I can't really replicate the sound, but like he has like this sound logo of his when you listen to a video from him. So it's I love this type, and it would be really fun to learn more about it actually.
Yeah, and it's interesting because you can have so many different combinations of these. Like McDonald's has uh, both letters,
Do-do-do-do-do-do-do-do.
yeah, sound, colors. I think John Deere was a good example.
John
Uh,
Deere.
yeah,
Who's
they
that?
are manufacturing uh, industrial vehicles, so to say. So
Okay.
everything from like tractors to uh, big, what do you call them? Harvesting machines,
Right, right, right.
if I'm not mistaken.
All right.
Uh, but yeah, I think they had a specific green color
All right.
that is specifically there. Yeah. Um, but yeah.
Interesting. And another notable thing we can bring up is like all these intellectual property types that we are going to go through. Uh, I think they have this one thing in common where they can be like registered. Uh, what was it like? It was like three. Was it locally, nationally, and internationally? If I'm not mistaken. And I only
Yeah,
see.
national, regional, and international.
Yeah, yeah, yeah. So I think that they all have that in common, even though I can't see uh the local name anywhere here. Like in the uh in the trademark section, but yeah, at least they can be registered like nationally and internationally.
Yeah. And
And
it's funny because I was
yeah,
also thinking, yeah, sorry. I was just, talking about trademarks and, sounds and so on. It's interesting how some artists actually put their sort of, okay, DJ Khaled, for example, all the sort of songs or like, yeah, all of the songs that he's part of, he puts that sort of, that
he
would be his
screams in them.
trademark.
Yeah,
Yeah.
he screams.
Exactly. No, but I've seen like other artists.
Another one.
Yeah.
We the best music.
Yeah. I've seen other like artists are doing it like differently, but they are sort of putting their own touch on it, which is kind of interesting.
Well, sure, yeah, like especially in the producer community, so to say. I think most producers have their own tag, which is their trademark.
Yeah.
So for
Yeah.
sure.
That's
Uh,
cool.
and then another interesting fact about the trademark protection or the trademark intellectual property is their duration. So when you apply for the trademark protection, it is like legit for a limited period of time. And in this case, at least in EU, when you register your protection, I guess, or your trademark, it lasts. Wait, so what the protection lasts for 10 years from the date of filing filing of the trademark application, and it can be used. It can be usually renewed indefinitely for periods of 10 years. This protection may lapse if the renewal fees are not paid. Once a trademark expires, protection ends, and anyone can use it uh, in the course of trade in relation to the goods and services covered by the expired trademark without infringing it. So yeah, it can be basically be owned forever, right? Uh, with
Mm.
the pattern of renewing the trademark every 10 years. That's what's up.
Yeah, that's what's up. Good. So, shall we go to the next one?
We can go to the next one.
Yeah. Because I would say trademark is kind of it's not that uh, hard or like complicated to explain.
Yeah,
Um, and it could be, yeah, as we said, it could be a sort of combination of, yeah, words, numbers, logos, and so on. Uh, so yeah,
for sure.
yeah. So the next one would be industrial designs, right?
Yes, sir.
This one, this one seems a bit more complicated, to be honest. Uh, but what do you think about it? Or what
Nah,
is it?
well, this is the example that I brought up uh, in my answer when I answered why I think this is important to talk about because this is kind of prevalent throughout history with many founders when they because I assume this is I'm not sure I would assume this is a type of patent if I'm not I can't really distinguish between the patent and the industrial design at the moment, to be honest. But so it says basically, an industrial design is the outward appearance of the whole or part of a product resulting from the features of, in particular, the lines, contours, colors, shape, texture, and or materials of the product itself and or its ornamentation. And then I have like some examples of I don't know what that could be like a special type of I don't know, maybe like a special type of what you call it? Like a detail or like what you call it? I'm not sure. I'm not sure. But like a special
Yeah, I
type of
mean,
cork or whatever.
yeah. I think these are very, very much used in, yeah, as the name says, like industrial, in the sort of more industrial world, where you have all kind of different details and tubes and what would you call them?
Almost like pieces of equipment-ish.
Yeah, exactly. That could improve or yeah, make your business more efficient or your machines more efficient. I think this could, yeah, like a very good example of this could be in the F1 Formula One. Uh, I don't know
Okay.
if those are like, but I think that teams could use like some patent stuff or like, to sort of make their cars
More
uh
exclusive.
more exclusive and like yeah, everyone will make their own modifications to sort of make it more to make it more performant and more efficient or
But are you sure? Like, I'm not sure if you can like protect your. I don't know because it feels like in that case you have to, or that team has to come up with like brand new part of the like a part that they can put in the engine somehow, or like some like new part.
yeah, but I think there are like many people behind the cars or like I mean the team that you see is just like the team that is actually there during
The
the
race, yeah,
races. But then there are a lot of people that are trying to develop the whole system, the car, that
yeah,
are working on it and trying to find different yeah pieces that they could add to the sort of engine or yeah,
exactly, yeah,
just different details that could improve the car.
yeah,
Um,
for sure.
so
Oh, interesting.
yeah,
But would you say that it would be like that the protection would be under the name of industrial design, or would it be more of a patent? And as I said before, I'm not really sure of the how they differ because it seems uh pretty alike to one another. But yeah, well at least you like the protection duration is limited in time, 5 years from the date of filing of a design application in most countries, which can be renewed for periods of 5 years up to a total term of 25 years. So we can be renewed only 4 times.
yeah, yeah. Well, maybe yeah. Now that you're saying it, I don't know. I guess it could go under like the previous example that I said could maybe go both under the name uh could maybe go both under the name of industrial design
And patent?
um and patent. Even though I'm unsure, but it would 100% go under the patent thing.
Yeah, yeah, yeah. That is kind of where I'm leaning towards as well.
Yeah. Okay, so maybe it wasn't a very good example, but yeah.
But yeah,
Uh,
I think it could be
yeah.
maybe applied to like some uh what you call it uh when when you are calling when you're working in
Manufacturer.
oh when you build stuff as a builder. Bob the Builder.
Yeah.
I don't know, but like yeah, maybe you can like have some protection for some kind of machine that helps with I don't know, building houses or whatever. Like I don't know.
Yeah.
Well, whatever. Let's go to patent.
All right. Patent. Huh. Okay.
So you want to read the summarization or the first
Sure.
sentences?
Yeah. So a patent is an exclusive right granted for the protection of investors in. I'll take that again. I feel that I'm completely lost today. Uh, a patent is an exclusive right granted for the protection of inventions, products, or processes offering a new technical solutions or facilitating a new way of doing something. So yeah, the patent holder enjoys an exclusive right to prevent third parties from commercially exploiting their invention for a limited period of time. And in return, the patent holder must disclose uh, the invention to the public in the patent application. Yeah. So
Right.
that's the funny thing, because there is like I think I had this during a course, which is it's kind of risky to actually apply for the patent or actually send in a patent application because you will have to write down all the details and everything that, like what do you actually want to patent? You have to
Mm,
explain it, right? And the thing is that if you're not accepted, all of your details will be out there.
right.
So it's kind of a risky thing, I guess,
It's a bit
for some
iffy.
people.
Okay. Yeah, yeah, yeah.
Yeah. But I mean, if you are 100% sure that you will obtain it, I think then, yeah, it makes sense.
Yeah. Then I think it's maybe intelligent to get in contact with somebody that has gone through the process and maybe can give you some advice how to more clearly define what you want to patent or like want to protect.
Yeah.
I don't know. I'm just thinking aloud.
Yeah.
But here we have at least we have the national route, like that you can take to have the protection. So you can have national protection, regional protection. So it wasn't local. So it was regional. It was regional protection, and then you can have also international protection, right?
Yeah. And I think the prices vary from which one you choose, obviously. Makes sense.
Yeah.
Uh, but I think there are different fees that you need to pay, if I remember correctly.
Right, right, right. Do you know the range?
I'm not sure, no.
All right.
I'm not sure, but I know that you have to pay something. Um, and I don't exactly remember if you have to pay every time you renew it or every time you apply, or if you have to pay for it regularly because you have a patent product.
Um, well, I'm not sure, but here in this PDF it says that patient protection is limited in time 20 years from the date of filing of the patent application in most countries. The patent may lapse earlier if the annual fees are not paid, so it's an annual type of
Annual fee.
deal, yeah.
Yeah.
Once a patent expires, the protection ends, and anyone can commercially exploit the invention without infringing the patent. So there we have the patent, and I guess did we have like some? I don't know. Maybe we didn't have like any specific examples, but yeah, I would say that it is what I have heard is it is like specifically applied to like new inventions and the products, right? So I think maybe the fidget spinner could be a easy example to.
That's, that's a good one, actually. Yeah. Um,
Lucky son of a man. I was like, yeah.
yeah, the one that if you actually invented the fidget spinner and patented it all over like internationally, I think that man or woman or yeah, uh, I think
That
they are
person
just,
They
That
probably like
person.
joined the what you call it, the Illuminati. Illuminati.
Yeah, exactly. Uh, yeah. Yeah, and then I actually watched a YouTube video on this on like patent. And
Hmm.
according to that video, there were like three criterias that had to no patents could be sort of divided into three parts. And it was utilities, design, and plant. And the last one is the most interesting, because the first one, utilities, is basically like, for example, a fidget spinner, right?
Yeah.
Uh, it's something you use, or like a vacuum cleaner. If you would be have been the first person to invent the vacuum cleaner, for example, and then um, design would be how it looks like, right?
Hmm.
Uh, so if it has like a specific shape, or yeah, whatever, and then plant was actually it was based on plants because it was I'm not sure how to explain this, but like there are like new type of plants that are invented, created, so you could actually patent those because those like some plants could reproduce asexually.
Wait, you're talking about like different products, like overall? Because I was
Yeah,
I was
yeah, yeah, yeah.
because I
Like
was
different
focused
parts.
on the vacuum cleaner, and I didn't really see where plants come in the picture.
Yeah, no, 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 no. I was focusing like different, yeah, like different, yeah, different type of patterns. Sorry.
Right, right, right. Interesting.
Um,
Even though it makes sense because
yeah,
yeah, you can like breed you can like crossbreed however you want, I assume, in the plant world, especially if you have a lab. So.
yeah. I mean, yeah, I want to get deeper into the plant part because I'm not 100% sure of how it works. But yeah, I just found it funny and interesting actually that it was like a there
A
was a
thing.
thing.
Yeah,
Yeah.
for sure.
So
Yeah, it's I didn't know about it either.
yeah,
So yeah. Hey, cool, cool, cool.
yeah. And then there were some different criterias for the to actually obtaining a patent.
Yeah,
I think yeah, the first one here is novelty, and you basically must show that it's something new that you have created.
yeah.
And I think according to some lawyers, I think that was the hardest part because at the same time you can't use this is so complicated. Now we are getting down to laws and stuff. But you can't use somebody else. So if you, for example, have one thing which is patented, I can't use that in my robot
Mm-hmm.
and patent that one because I'm using your patent product already,
Right.
which would yeah, it doesn't make
Ooh.
sense. However, what you are allowed to do, I can, for example, take your product and improve it and make a patent of that one.
Mm,
That would work.
right.
So that's interesting actually to consider those types of sides of the whole regulations and laws and so on
Yeah, yeah, yeah.
and how you apply it.
Well, yeah, 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 yeah. Sounds interesting for sure. Uh, and that is like exactly how James Dyson did it as well. Like, yeah, I think he was the first one who created a vacuum cleaner that works without the bags.
Oh, okay.
And I actually looked up his vacuum cleaners today, they're pretty expensive, but it's said that they are pretty good. So yeah, I know what I'm getting.
All right.
But yes, that's basically an example of what you were saying of
Yeah.
improving something that came previously.
Yeah.
But okay, so wait, so then we also have a thing that is called a utility model, which is also referred as a petty patent. A utility model is an exclusive right granted for invention, which allows its owner to prevent others from commercially using the protected invention without their authorization for a limited period of time. But how does that differ from the actual patent, though?
Oh, the fourth. You're on the fourth one right now, right?
Am I?
Yeah, utility models.
Ah, damn it. I thought this was a gonna with the patent, but okay.
But I think we could jump to the utility models.
Yeah, we have probably said it. Yeah,
Yeah.
probably said everything we know about patents.
Yeah.
But yeah, so like I said, before realizing I messed up, that a utility model is referred as a petty patent. A utility model is an exclusive right granted for an invention, which allows its owner to prevent others from commercially using the protected invention without their authorization for a limited period of time. Yeah, I'm not really completely sold on this one. I'm not really sure how do they differ from like a
To be honest, I think that there are like three main categories when it comes to like intellectual properties on the whole. So that would be like trademarks, patent, and we had another one.
industrial. What was it?
Oh, and copyright. I think there are like three main sort of categories, and then you could sort of uh, come up,
Distinguish or
yeah, come up with like subcategories for them. And I think like the industrial design would be like a subtopic of the trademark or uh, patent
okay.
because it feels like they are all very interrelated somehow,
Mm-hmm.
uh, which could make it also a bit complicated if you are thinking on applying or something, right?
Yeah, yeah, yeah.
Uh, I mean, sure, if you have invented a new car or yeah, maybe not a car, but if you have invented like a utility, maybe it's good to apply for a patent. Like,
Yeah.
but yeah, um,
But here it says that okay, so here it actually kind of tries to answer my question. So what are the main differences between utility models and patents? The main difference between utility models and patents are the following. The requirement for acquiring a utility model are less stringent. I don't know what that word is.
I think it's I think it's less
Strict, regulated,
exactly, yeah.
uh, than those of patents. While the requirement of novelty is always to be met, that of inventive step or not obviousness is much lower. Right. And therefore, protection for utility models is often sought for inventions with a limited inventive step, which may not meet the patentability criteria. Right. The term of protection for utility models is shorter than patents and varies from country to country, usually between 7 and 10 years, without the possibility of extension or renewal. And then the fees for obtaining and maintaining utility models are generally lower. Right. So it's like a lesser version of patents, so to say.
Yeah, it's a cheaper version.
Yeah,
Uh, it's the beta,
beta. Yeah,
the beta version of it. Yeah.
beta.
Uh, yeah.
For sure. Sounds like
Yeah,
it.
exactly.
All right, should we go next to the next one?
Yeah, let's go to the next one because yeah, I think yeah. I mean, we covered patents and we sort of went through it, and this is like the beta version. So,
Exactly, exactly.
uh,
And this is also also this is actually the one that I'm most excited about, or like I thought this was the like really interesting.
yeah.
And that is trade secret.
Mhm.
So what is a trade secret? Any confidential business information providing a competitive advantage to an enterprise can be considered a trade secret. The type of information that can be protected as a trade secret is therefore highly diverse. So yeah. What's your thoughts on this?
Well, it just makes me think of Coca-Cola. Uh,
Okay.
and their receipt, right? Recipe and their recipe.
Yeah.
The receipt, the recipe. Yeah, no, yeah. So just Coca-Cola, because yeah, I think they have like a trade secret, which would be their recipe, as I mentioned. Um, and yeah, it also said that it could include know-how, technical knowledge, potentially protectable as a patent. Makes sense. But also business and commercial data, such as the list of customers, business plans, recipes. Here we have the Coca-Cola and
Yeah.
manufacturing processes. Yeah.
Right. Oof. Oof. I would
Um,
like to get my hands on some of those.
yeah, but the interesting thing is that, when it comes to like the trade secret could include know-how. And when it comes to know-how, it is, I feel like it's more connected to knowledge.
Yeah.
And oof, I think this is like a very deep topic. How would you transfer knowledge?
What do you mean?
Could knowledge be transferable?
Well, yeah, it has been transferred from generation to generation.
Like the exact knowledge.
I'm not sure what you mean.
Could it be transferable between like or some skills? No, because we had like some courses about this. It was about like uh, multinational enterprises and how you sort of transfer knowledge between different subsidiaries uh, and between different countries and cultures. And then there are like several. Um, okay, now I'm going on the wrong way. Like I'm zooming out. I'm starting to focus on something else.
Yeah, interesting. Like, I don't know. Like, for me currently, I think knowledge is information, and I can't see how it couldn't be transferred. So I'm not. Yeah, yeah.
Yeah,
I'm not sure, but we can probably maybe bring it up in some other episode, and maybe talk more about it in like off record, so to say.
yeah, yeah, exactly. No, because it feels so easy. Like, yeah, how do you transfer knowledge? Well, it's kind of easy. Like, you write a book with all the information, and there you have it. But I don't think it is as easy as it sounds. Uh,
It sounds like you are high on weed, Costin.
no, but
No,
no,
I'm
but I
kidding.
mean, if you think about it,
You just
no,
read the words, you implement it practically, and there you go. You have the knowledge.
Yeah. Yeah, maybe I'm thinking of it between. Yeah, okay. Yeah, I'll try to. Okay, I'll leave this for another day. Um,
Maybe
yeah.
you are, I don't know, maybe thinking like in between companies, or I don't know,
In between
that
companies, in
could be like,
between.
I don't
Yeah,
know.
we
Well,
will. Yeah, let's pause that topic for a
yeah,
minute and
yeah.
continue on this one. Uh, okay, yeah, but good. Um,
All right, so I wanna jump into this. So how are trade secrets protected? Trade secrets do not require administrative or procedural formalities in order to be protected. These are, however, some conditions for the information to be considered and hence be protected as a trade secret. The information must be secret, meaning that it is not going to be generally known. It's not going to be generally known. Have a commercial value due to its secrecy, and have subject to the reasonable measures by the person in control of the information to keep it secret. These reasonable measures may include storing confidential information safely, concluding non-disclosure agreements where trade secrets must be discontinued, where the secrets must be discussed with business partners, including non-disclosure clauses within agreements such as license agreements, employment agreements, consortium. What the heck is that? Consortium agreements or partnership agreements, where the exchange of confidential information is very likely and or necessary. Yeah. So I don't know how to elaborate on that. Um, well, yeah, basically that the secret has to be like working, like it has to work, within the company. It has to generate some legit results for it to be protected, right? That is my main takeaway from what I read.
yeah, it
Uh,
must be. Yeah, it must give the company basically a competitive advantage, right? I think that's the key word, I would say,
yeah,
or at least in my ears.
yeah, mine too.
Yeah. Um,
Interesting. Like I didn't know that you could protect your competitive advantage, so to say. That's interesting.
yeah, and it makes sense though. And
How?
I'm fascinated of how Coca-Cola still has their recipe. No one has been able to sort of copy it,
Right.
even though there are so many attempts, right? Because
Yeah.
we have all kind of like different other brands
Colas, yeah.
that are trying to come up with something similar. But yeah,
For sure, for sure.
mm,
And also, like I mentioned, a non-disclosure agreement. So a non-disclosure agreement, also called a confidentiality. Is that how you say it? Confidentiality agreement is a legally binding contract in which one party, the disclosing party, agrees to give a second party, the receiving party, confidential information, and the latter not agrees not to disclose this information under the conditions set by the contract. So basically, that a company that shares its secrets, so to say, the receiving company has to keep its mouth shut. Contract, or like what you call it, by contract.
Yeah, and that's the interesting thing. That's yeah. Okay, no, I won't start on that topic. Uh,
Casting the philosopher in the house,
yeah,
ladies and gents.
when it comes to knowledge, what can knowledge be transferable?
That's the question of the week.
Yeah, and especially amongst businesses. Uh,
All right. You want to
yeah,
jump to the next one?
yes. So copyright. Okay, so copyright. I think this one is also very, very well known. So besides patents and trademarks, I think copyright is also on like on the podium.
Yeah,
Um, and so what is copyright? That is the question. And so copyright, uh, or also defined as an author's right, is the term they use to describe the rights that creators have over their literary, scientific, or artistic works. Uh,
for sure.
so yeah, uh, and these
And
works, yeah,
yeah,
go ahead.
no, you can continue.
No, no, no. And I mean, these works would basically be covered, these these works would be like poems, plays, newspaper articles, computer programs, databases, films, paintings, sculptures, architecture, advertisements. I didn't know it was also applicable to advertisements, but it kind of makes sense. Maps, maps. What? What? You can't copy a map, but there are so many copies of maps though, and
uh,
technical drawings. Oh, but maybe yeah. Okay, never mind. It's
yeah,
not the.
yeah.
Yeah. Okay. Yeah. Uh. Yeah. Okay. Yeah. I mean, yeah. Here's the thing that you can actually copy these things, but you have to refer back to the artist or like pay them. Like you can't have any, or I guess you could, but you have to pay a percent. You can't. I was just about to say that you can't have any commercial benefits from taking somebody else's work. Uh, but that would be wrong because I think I mean, it is possible, but you have to pay sort of a royalty or something to the artist, right? I mean,
Yeah, and also there are different types of copyright like protections as well. There are like I think it was like some they had some numbers like O O2 or like something like that, like copyright O2, like and then it and there also were like copyright free, and also there is a copyright protection that is I'm not sure if that is the official name, but there is like a protection copyright thingy law that is called Creative Commons.
hmm,
So you can like use that I don't know picture or beat song for only creative purposes, but not for commercial purposes.
hmm. Yeah, that's
So
interesting, and I think there are so many laws or like yeah laws I would say regarding this, and they could be interpreted in so many different ways. Uh, so yeah,
yeah, yeah. It's a headache. So I'm happy that we are briefly kind of skimming through all these types of predictions.
yeah.
Or yeah, but yeah, another interesting like thing that I want to bring up like related to copyrights is a thing that we talked about before we started to record, and it is called moral rights, right? And I assume I still think this little section um, in the page 33 down in the right corner is about moral rights, even though it says like automatic protection and like how copyrights arise, but it says that the EU copyright protection is obtained automatically from the moment when the work is created, and no registration or other formality is required. However, some countries allow for the voluntary registration deposit of works protected by copyright. Therefore, registration is not constitutive of the right, but can be useful in some situations. Example, to solve disputes over ownership or creation, to facilitate financial transactions. Um, yeah, I'm not sure. Like, I'm still kind of confused, but basically, moral rights, like how they differ from copyrights, is that they protect like the creator, right? Or the created piece of like, how was it? It's
I just got a
uh
feeling that is more connected to the integrity of the creative,
integrity.
yeah,
Yeah,
and their reputation. I think we said,
yeah, exactly. And meanwhile, the copyrights are more strictly focused on the financial side
yeah,
of it all, right?
yeah,
And moral rights are basically obtained.
automatically, yeah,
What?
they are obtained automatically.
But I'm not sure like how like what they mean by automatically, since when we read about moral rights, it said that they are basically what you call it, like activized, no,
Activated.
activated. This the at the time when you buy or like attain the copyrights for the work. So I'm not sure like how what they mean by automatic protection, to be honest. So I'm a bit clueless on that one, to be honest. But yeah, it's a thing, and this is so stupid. But yeah,
But it feels like when you obtain this copyright protection
yeah,
to your work or whatever it is, then the moral right is included in it.
yeah. But I wonder why there is a separate word for it. Like, couldn't it be just as a uh protection ish thingy, like under the name of copyright? No, I don't really get it why there is a separate name for it.
I think the separate names come from all the different laws. Uh, because they are, yeah, it's kind of. I think when you're actually adopting a law, it can't be too general, but it can't be too specific either. So there must be left some room for interpretation,
Why?
I guess. I don't know. I'm
Because
like what I said. I'm not a lawyer. Yeah, I'm not a lawyer, so I'm not sure about it. But it feels like all these different and more of a difficult and complicated expressions are because of how the laws are actually built around them.
right, right, right.
Um,
Yeah. Interesting. Okay. Um, we should maybe mention the duration of the protection. So this is a bit different from all the other like durations, so to say, because the copyright duration can last like your whole lifetime, basically. I can read what they have written. So while moral rights have usually no time limit, they last forever. Economic rights are limited in time. The Berne Convention establishes the economic rights must last at least during the author's lifetime, plus 50 years from his death. However, national legislation can provide longer protection, e.g., in the EU, 70 years from the author's death. So it basically lasts your whole lifetime plus 50 or 70 years after you have gone to heaven. So yeah,
Hmm. Yeah.
that's a bit unique. That is
Yeah.
why I've seen like on YouTube there are people who make these playlists of songs that are from like I don't know the 40s or like I don't know. Yeah, they are on a hunt of to like hunt down songs um where their like copyright has like expired.
Oh, I see.
Yeah,
Hmm. Okay.
so that's a thing as well.
Yeah.
Jingle bell. Okay.
Okay. So the next one would be, shall we jump to the next one, or what do you think?
Yeah, if you don't want to bring anything more from the copyright section, then I'm good to jump into
I
that.
mean, not necessarily from the copyright section, but regarding knowledge. No, I'm just kidding. No, but I had
You're actually right. I thought about.
yeah.
Can't really be
But I
transferred
mean,
that easily.
regarding trademarks and so on, I had a teacher and he basically created a website, which was called something with times.
Okay.
And this teacher was actually he was a lawyer. We had him in one of the international, yeah, it was a law course, and we had him, yeah, as the main teacher. And he created a website called Times, and he explained that a few like weeks, months after he registered the website and so on.
The domain, yeah.
Yeah, the domain, and I think that that was actually his business as well. Like his business, it was his business website. He got like a letter from the, do you know the New York Times?
Yeah. I've heard about it, yeah.
Yeah. So he got a letter from them, uh, and he said that it was a huge letter with like I don't know how many lawyers' names
Mhm.
that tried to basically scare him to change his name.
Okay.
And he was like this teacher was a badass because he had like a lot of experience in
Hmm.
like he explained that he had been in different cases and board members he had been board members and stuff. So like he was experienced and he knew what he was doing. So he was like, yeah, so sue me then because you can't actually trademark the name time because he was something with times. So he like what they could reconcile was just times. So they had
Right.
something with his business being including something with times, and he was like, "Yeah, so sue me then, because you can't own the like you can't own the name times. That would be crazy.
Yeah, but like yeah, it's interesting. Like, isn't that a bit of a slippery slope?
It is, it is.
Like, what words you can own and can't own? Like,
Yeah, I mean it is, and it's like
what if somebody else owns my name?
yeah,
Shit.
yeah. You'll have to pay taxes on it. That'd be crazy.
Royalties.
Yeah, royalties or some different name tax name.
Oof.
No, but that was just an interesting case, when he told us about it, it was just like, yeah, and it makes sense. I mean, well, you can't just, make a business successful and name it like dogs, something with dogs. And then every name or everyone that says dogs or are using the name dogs will have to pay you royalties. That wouldn't make sense. So yeah, that's about it. I mean, then again, it comes down to how you interpret the law.
That's yeah, that sounds really complicated because like yeah, even if you come up with a random name, like let's say you do like Hans Wilsdorf did with Rolex, right? And then they like just basically try to come up with a original name. Even if you do that, like it could mean something like general in a another language. Like
Yeah.
that's
I
so
will
that's
create a website called Amazonas. They will come off. I'll come far away. No, but
yeah, I will create a website that is called Face Bookies. I don't know.
yeah, Facebook. Yeah. See you in court, mate.
Yeah,
Yeah.
I'll see you. I've already bought a suit, so I'm
Yeah.
good.
That's nice.
All right, so databases, right?
Yeah,
That
talking
is
about Facebook and Facebook is databases.
that's actually a pretty good, somewhat of a good segue. Yeah.
Yeah.
So basically, you can also have protection for your databases. So in EU, a database base consists of a collection of independent works, data, or other materials arranged in the systematic or methodical way and individually accessible by electronic or other means. Ooh, that is so not my area of expertise, so to say.
Now develop it, Image. Please
So yes,
elaborate on it.
as you know what a database is. I can't explain. Uh, but yeah. What are the routes to database protection? You can have copyright protection. So original databases can be protected by copyright. Copyrighted databases must be original intellectual creations. See section 6. No, thank you. Uh, copyright in the highest level of protection that can be obtained by databases in the EU. The owner of the database is the person who creates it. Yeah. Basically, there you can have protection for databases. I'm not really too keen to go more in depth. Yeah. Do you? I think you are the IT expert here, Carsten. So I think you
Oh.
should um uh
Thank you for passing me this.
you should
Yeah.
elaborate. What do they mean?
Uh, to be honest, I'm not the IT guy either, but I think I would interpret it as, a database or like, yeah, a database could include several others. I mean, I wouldn't even put this as a sort of a, yes, sure, intellectual property as a database. But I think it depends on how you look at it because it could also go, as you said, under the copyright protection. Uh, but it
Yeah,
feels like it could include like several others. I mean, it could also go under the, what would you call it? The trade secrets,
right.
right? Like database, you will have a lot of information probably about your customers,
Yeah.
which which could be related to this competitive advantage and so on. Um, so there are like, it depends from which side you look at it from.
For sure, for sure. Uh,
But in the EU,
yeah,
we also have this GDPR,
right.
General Data Protection Regulation, I think it is.
Mm-hmm.
Uh, yeah, which is a regulation about like how different organizations can store your information in their databases.
Right.
Um, so yeah, it's funny that they don't mention anything in this. But yeah, maybe it's not like a that wouldn't be a specific. That's more of a regulation and not like a patent or like a intellectual property. Or what
Well,
would
I
you?
don't know because uh had to belong to the creator or like I don't know.
Yeah. Um.
Well, here it says the copyright thing, right? It says here on page 41, down in the right corner, copyrighted databases. Protection is conferred to the structure of the database and not to its contents. So there goes the trade secret category,
Oh,
right?
yeah.
That is a reward is given to the efforts made in selecting and arranging the contents rather than in creating them. However, an individual item of the contents may enjoy separate copyright protection if it complies with the applicable legal requirements, e.g., a photograph included in a database. Okay, okay, okay. So that is like strictly for the database, like as a entity, like I don't know.
So that yeah, as you said, it's strictly for the database. So that would be just the data, like the database itself, not anything else that it includes.
Yeah,
Um.
not the content. Yeah,
Yeah. So that would be like the programming, if I'm not misunderstanding the whole thing.
I'm not good with computers, Mr. IT expert. I'm not, I don't
Okay.
know.
Um.
But yeah, like the hardware, I assume. I don't know.
Hardware,
Well,
I would put it as a software.
I don't know. To me, when I think of a database, I think of these big boxes.
Yeah. Okay.
So, but I'm gonna keep quiet, Mr. IT expert.
Yeah, I'm not an IT expert either. Uh,
No,
but I would, yeah,
I'm just
I
kidding.
would think on it on the other way. I would think of it as a more abstract thing, like how you the page itself maybe, and and the codes and everything behind it.
Yeah.
Well, maybe I'm wrong.
I'm gonna keep quiet about this.
Uh,
All right, people. So next next intellectual property, or I don't know if it even stands for property. I feel like it could just as well stand for protection, intellectual protection, or I don't know. Uh, but yeah, it's a domain name, and yeah, you mentioned your professor
yeah.
uh, had created this website, so I guess that could be a good example too. Yeah, that was a good example uh, related to this. So, but basically, the kind of the summarization of what a domain name is that according to WIPO. I'm not sure what that stands for. Domain names. Wait, maybe I can access it. WIPO.
I think it's like world.
Intellectual Property Organization.
Yeah.
D'accord. Uh, the World Intellectual Property Organization domain names are the human-friendly forms of internet addresses and are commonly used to find websites. For example, the domain name uh, iprhelpdesk.eu is used to locate the European IP help desk website at.
See- Okay, yeah, continue.
Why are you being mean to me, man?
No, I'm just not. I'm
You're
not being
laughing.
mean. It's just funny. Like, oh, you like, it's like you're doing an advertisement for the European help desk. Like, please access iprhelpdesk.eu, which is located at the European IP help desk website at http www. Oh,
Yeah, yeah, yeah. So IPO, nee, iprhelpdesk.eu, sponsor us. Ah, shit. Okay. Apart from this function, domain names are also serve the purpose of identifying a company or a trademark on the internet. So yeah, that's basically uh what's up.
and talking about investing and so on, I heard, I'm not sure if this is true. I think it is true. It may be true, but I've heard that before, um, there were people actually trading domains.
Yeah, yeah, yeah. Like flip.
Yeah, flipping domains. So I
Yeah.
think, yeah. So that could be an investment, I guess, if you buy the right one.
Yeah, 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 for sure. And I think I don't know. I think it worked more like like swing trading almost, like a I don't know. It doesn't really seem to me as a long-term investment that you hold, or
Oh
maybe
no.
it could be. I don't know.
I mean, it could be, but I don't think it's the same thing as, trading stocks.
Yeah, it's not like
Yeah.
profitable in that sort of way. Because I assume they. I'm not sure actually, but I wouldn't think they go up in value. Depending on the name, maybe. I don't know.
Yeah. Yeah. I think that a lot of people are actually buying depending on the names. So if you, for example, let's say I buy some random ass name, and then, there is like a company that is starting up, and then in like 10 years, or okay, maybe not 10 years, but in like 3 years, they are like becoming huge.
Yeah.
Then they would obviously like to sort of buy that name or try to, make sure that no one else can uh,
Right.
yeah, use it.
For sure. Yeah.
And I think it was something similar with Elon Musk and Tesla, because I think someone owned the name Tesla.
Well, yeah. Like there was this inventor. What was his name?
Nikola Tesla, yeah,
Yeah.
but
Yeah.
but I think there was some other dude that had the trademark for Tesla
Right.
or something, or maybe I'm mistaken. But I remember that Elon Musk had to like convince him somehow, or it was anyway. Yeah. Um,
We can talk about it when we do an episode on Elon Musk.
yeah, exactly. Um,
But
I think
yeah. So yeah. Go ahead.
no, I was just about no. You go ahead.
All right. So thing that I wanted to bring up with these domain names is again the duration of protection. So when you file the paper for a domain protection, you can it lasts for 10 years. Then you can renew the contract or the deal for, yeah, 10 years at a time, uh, forever. As many times as you want. So that is basically how that seems to work. Yeah.
Yeah. Yeah, and here again, you could yeah, in the document that we are looking at, they have like they have divided it into three different levels, right? Um,
You mean like three different levels of protection?
no, like the domain name has been divided into three different levels,
Right.
which would be like the top level would be like the dot EU or dot com or dot SE or dot UK or dot uh,
Right.
org. Um, and then we have the
Indicates in.
second level and the third level, which would basically be the the I
What a
pro
funny picture it was.
yeah, I can imagine. My internet is unstable as always. Um, yeah. No, so yeah, I think I explained the top level.
Yeah.
And then we have the second level and third level, which would basically be that if you have two names, you could put a period between them and sort of divide them into. So if we would have philosophy culture, the third level would be philosophy, the second level would be culture dot com, for example, which would be the top level.
Wait, so like the dots determine like what level it is, or
Apparently it does, yeah.
okay.
Here it says the top level domain is located after the last dot. Second level domain is located directly to the left of the top level domain.
Right.
Third level domain is located directly to the left of the second level domain.
Hmm.
But that also means that they could have like several levels, I think.
Yeah, yeah, yeah.
Um, so yeah, I think, for example, Facebook, that's just facebook.com. So they just have like a top level and second level.
Yeah, yeah, yeah.
Yeah. Okay, good. I never thought about breaking it down like that, but that's interesting.
Yeah, for sure. No,
Um,
my cane is acting up on the mic.
all right.
Ah, it's okay. It's
Yeah.
okay now.
Yeah, now I can hear you like 30 times better. Uh,
Oh, perfect, perfect, perfect. No, my dad was in the other room,
yeah. Yeah, like
so
we
I
couldn't hear him at all, so it's fine.
well, yeah. Let's hope so.
Yeah. All right, so the last one is the geographical indications,
Yeah,
which would basically be explained as a geographical indication or GI is a sign used on products having a specific geographical origin and whose qualities and or reputations are attributable to that origin. Ah, yeah. So it feels like every pizza has like the Italian flag on it
yeah, yeah, yeah,
somehow, uh, no matter where you buy it from. And then we have all these, the Turkish yogurt.
yeah.
Yeah, the same with that one. Uh,
Well, wait, I don't really get it. Like, how is it? What is it protecting? Like protecting against?
Oh, the Greece says the feta. Yeah, that's true. The cheese, feta cheese. Okay, yeah, sorry.
Yeah,
That would be protecting
that's really like interesting fact actually about the cheese.
yeah, I didn't even think about it. But I
That
think
feta cheese is not named after a place, but after the Italian word feta, meaning slice, which was incorporated into the Greek language in the 17th century. However, several factors such as the fact that 85% of EU consumption of feta cheese per capita and per year takes place in Greece, or the fact that feta is usually marketed with labels referring to Greek cultural traditions and civilization, make EU consumers perceive feta as a inherently Greek product. Okay, so in that case, where does the protection really come in?
I don't think this is a specific protection. It's more of an indication, as the name says.
Oh, okay, okay, okay.
So yeah,
But like no, like but it has some protections. Like yeah, here in page 53, what kind of protections do GIs, so geographical indications, confer like a grant? So it grant or like yeah, gives territorial protection. GIs are territorial in nature. Does where a specific right over a GI is obtained in one territory. It is protected there, but not abroad. Okay, but like, how would you break such or try to infringe on such protection? I don't really get that. Ultimately, taking. I think my gain is too loud, man. I think it's better now. Uh, yeah.
I think this could be more related to the cultural side of some product. Like, so for example, I'm not 100% sure about this either. Yeah, so GIs do not confer individual rights, such as the case of patents and trademarks, but rather collective rights.
Oh, okay. So
S-
I guess like another country or region or company could infringe on those rights, no? Like to kind of proclaim that their product is made in that area, or
Yeah. Yeah, like you can, for example, or maybe yeah, you can. GIs are territorial in nature. Thus, where a specific right over a GI is obtained in one territory, it is protected there but not abroad.
not abroad. So it is only like relevant in that one country, right?
I'm
So
not sure.
if you live in a region, you can't say that your product is made in a different region, or like have that as a trademarkish. No,
Yeah, I
I
was
don't
thinking
know.
about that as well. Because it would be like, for example, yeah. I mean, let's say that you're selling plates, plates with some Greek symbols on it.
Yeah.
I don't think you can like sell it in uh, Spain and say that they're Greek if you're producing them in Spain as well and they don't have any. or maybe you could.
since they aren't they are not like what you call it. They do not protect like abroad. So I guess you could.
Yeah, but yeah, I think that would be, I think that would still be some sort of infringement because you would basically lie that you have. I mean, let's say, yeah, as I said, like you sell some plates with Greek symbols on it and say that they are from Greek, even though you're producing them in Spain and you sell them in Spain. That would
All
be
right.
some sort of illegal stuff, I guess, because you would use a geographical indication even though it doesn't really come from that region or country or nation. It's the same thing.
Right. Well, yeah.
Yeah, so geographical indications protect your products against misuse or imitation of the registered name and guarantee the true origin of the product to your customers. So there we have it.
Okay, so it basically protects the product.
Yeah, in the sense it protects the
The product's uh
origin.
yeah.
Yeah.
Okay, but like I think a good example would be of champagne, right? Since champagne is made in the region of France that is called Champagne. I think someone told me in a alcohol store.
Yeah. Yeah.
Or like you know that you have like these specific names for wines as well. That
Yeah. Yeah. I
yeah
mean, they are usually named after the place from which they originate.
yeah. Well, doesn't isn't that a good example? Uh,
Yeah, yeah, I think so.
I
Yeah.
think yeah I don't know.
I think yeah, that would I think that would be one good example.
Yeah
And we have all these yeah. They also had a good example with the Greek food. Uh,
yeah.
I mean, if it has Greek origins, then yeah.
Right. Okay. No, I think I get it.
And the same with the plates. You can't the plates that I said you can't be selling plates in Spain saying that they are actually from Greek when you are maybe manufacturing them in Spain and they don't
Yeah.
have any sort of or maybe yeah maybe I don't know. Or maybe you could. That was maybe a bad example. Okay, now I'm getting really fuzzy again.
I'm just gonna stick to the wine, the
Yeah,
champagne, and the cheese.
yeah, the cheese is a good one. Yeah, and the champagne. Yeah,
So, uh, but yeah. Okay, so th this was intellectual properties. Do you wanna add something? Some last words?
I don't have so many last words to add. Just regarding the time or like the duration of the protection. Apparently, it is unlimited for this one.
Right. We should have mentioned that. Yeah.
Yeah.
So it's good
Um,
that you brought it up.
so that's interesting.
Yeah. Okay, wait. It's unlimited, yeah. Okay.
Yeah.
GIs are not subject to a specific period of but validity. This means that the protection will remain valid unless the GI registration is cancelled.
Yeah.
Boom. And then also like in every section, which me and Carsten have mentioned or yeah talked about, they also have further information. They refer to like documents and other sources where you can research and look up this stuff even more deeply, I guess, more in depth. So yeah,
Yeah. I think we'll add this document in the description, as you said.
for sure. Yeah,
I think that was a good idea. And yeah.
hell yeah. So remember to also visit IRP help desk.
.eu.com. .eu.
Yes. Visit them. They will help you. All right.
No, but I think it was a good document, to be honest, because it really, or I mean, the information was really sort of conclusive,
Yeah, concise, right?
concise, yeah. So it was good.
Yeah, I think so too. Thank you, the European IP help desk.
Which you can visit at the IRP. Okay, no. Okay, okay. All right, everyone. So thank you for listening to today's episode. We hope that you enjoyed it and got some new information about intellectual properties, which will hopefully help you navigate life's spin, at least to a certain degree.
For sure, yeah, and we hope that this wasn't too confusing, since the categories were like pretty similar at times. So yeah, we hope that it still brought you some clarity on intellectual properties. And yeah, comment down below what you think. Did we do a good job or not? We hope that we did a good job. Good job. But yeah, comment down below anyways, and subscribe. Let's grow together. Until next time.
Adios.